everybody, this is Deb with Truthification Chronicles, and I've got another video for you, but before I do, I have 2 points I need to make. First of all, if you watched my video, what happens after the arrests, please understand, I am not saying we need a new constitution. I'm saying we need to plug up some of the holes that our Constitution leaves. Because if you've ever actually read the Constitution, which I highly recommend, you probably notice that it paints in broad strokes. It does not fill in a lot of the little details. And it's those little details that have been filled in over the centuries that have given us the problem we have now with the deep state. And that's what I was suggesting, that those loopholes need to be closed. Not that we need a whole new Constitution. We don't. We need to take the Constitution we have and to flesh that out in ways that will close up these loopholes. Okay? So, understand that. I had a lot of people in the comments trying to accuse me that I was saying, oh, we need a new Constitution. Oh, no, no, no. No, we don't. And we also need the Bill of Rights. Yes, that's an important part of it too. Those need to stay, but they also need to be interpreted a little bit better and more clearly so we don't have all these continuous, what does this mean, what does that mean? And we also close the loopholes so that the deep state can't get back in again. Okay, that's what I was suggesting. So, then we go on to the next one. And the next one has to do with this. Okay. Now, I realize that this was monumental to some of you, but I need you to look at this for a minute and listen carefully.
Epic.
Oh, see?
Epic.
Yes, that's how I grew up hearing it said. And then some of you say the only way you can say it is this.
Epoch. Epoch.
So, there are 2 ways of saying it, and that's why I said both ways, and I said you can say it either way. Some people just didn't understand that, but look, this is the first one.
Epic.
I think maybe this is more of a British pronunciation, I guess, and maybe that's how some people in some places say it. But around here, it's
Epic.
And it's not pronounced the same as epic. It's really more of an epoch. You know, so there's a little bit of a vowel sound change in the second half, in my opinion, but that's how it's said. So I don't care which way you say it. It's tomato, tomato. Say it whichever way you want. But anyway, I just had to say that. I know, and it bothered some of you, and I'm really sorry about that. So I'll try not to say it that way again, or at least I'll clarify when I do. Okay, but I'm an old dog and it's hard to teach old dogs new tricks. Okay, today's topic is Carter Page and his lawsuit against the Democrat National Committee, Perkins Coie, and Mark Elias, and Michael Sussman. Ooh, he's hitting them all here. And look where he's filed it. Western District of Oklahoma. Now, for those of you who know a little bit about the courts, you probably realize that the courts around DC are very, very liberal, and also on the West Coast. So if you can stay somewhere in the middle, you have a much better chance of having a conservative court, a conservative judge. So, where is this one filed? In one of the most conservative places in our country, the Western District of Oklahoma. So I love that. Anyway, let's go on and see what it has to say here, because there's some pretty spectacular stuff in here. So if you go through, I'm not reading it all, obviously, because it's 49 pages, and I will put the link down below. So if you love reading court documents, you can do that. I'm going to try to point out some of the most important things that I've seen in just the beginning of it. Here they have the entire table of contents, and you can see it's quite long and everything, and deals with multiple issues along the way. Now, then they go through all the different authorities that they refer to, the cases they refer to, and various things. I mean, it's a lot. The statutes they refer to, and everything, and other authorities. Yeah, okay, constitutional provisions. Okay, so we get to this part. Yeah, this is page 9 already. So we start here. Plaintiff Carter Page, Dr. Page, respectfully submits to the court this memorandum of law in opposition to the memorandum of law in support of the motion to dismiss as filed by the defendant. Now, I'm not going to read a lot of the stuff in parentheses because those are like court cases and things, so I'm going to skip a lot, okay? As filed by the defendants, the Democratic National Committee, Perkins Coie, Mark Elias, and Michael Sussman. The preliminary statement. The plaintiff has spent much of the past 2 years repairing the damage inflicted by the defendants as a result of their false U.S. District Court declarations and associated media reports against him. Although the plaintiff's efforts have required that he file many thousands of pages to begin setting the record straight, this brief endeavors to avoid such unnecessary encumbrances at this early stage of the current civil action by alerting the court of several fundamental flaws in the defendant's motion to dismiss pleadings. During the months before the 2016 presidential election, the defendants committed torts previously unseen in the history of the United States and without precedent in the annals of American law. Okay, if you go on down here. In the wake of this man-made disaster, the November memo follows their familiar pattern of abuse of process in U.S. district courts that the co-defendants have helped to commit since 2016. To the contrary, the U.S. Congress has, in the years since 2016, exposed evidence that the defendants collectively conspired to concoct a bizarre and speculative narrative about the plaintiff as part of their multi-million-dollar defamation campaign. Woohoo! Does that just put it out there or what? These same inconsistencies follow the pattern summarized in this opposition brief, as similarly seen in the extensive 412-page falsified pleadings that the defendants caused to be submitted to the U.S. Foreign Intelligence Surveillance Court. I'll call it the FISA court. It's the FISC, but I'll call it FISA court, just for clarification. Based in significant part on the defendants' quote, opposition research report regarding fabricated allegations related to the plaintiff and other such collateral targets who had supported then-candidate Donald J. Trump, the, quote, dodgy dossier. Their memo thus blatantly defies the rule that, quote, factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Their roughshod legal analysis fares no better, characteristically defying the principle that, quote, defenses and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law, unquote. This all follows the defendants' erstwhile attempts to secretly extend, modify, or reverse existing law or establish new law in the FISA court, where the defendants creatively transformed themselves into artificial creatures responsible for the harm inflicted by those through whom they must act, so long as harm is inflicted while the agent or servant is on duty, on the job, or fulfilling an employment-related mission. Instead of focusing on legitimate facts or relevant legal analysis, the defendant's memo accordingly reverts back to their usual standard pattern in the FISA court from recent years by seeking to discredit the plaintiff through citations from reliable mainstream media outlets which have often worked on their behalf in the past. For example, citing a segment from Dr. Page's unrelated TV interview by ABC News that had nothing to do with the core defamatory allegations that the defendants underwrote and caused to be submitted to the FISA court. Having previously overstepped many FISA court safeguards in a way that remains symbolic of their pattern of arrogance and audacity in U.S. courts, as once again seen in their memo, The defendants now disrespectfully and ironically claim that the Western District of Oklahoma should have no jurisdiction. Of course they don't want it happening there, because they know it's going to be a conservative judge. For understandable reasons, the defendant's memo primarily focuses its references regarding alleged defamation towards the libelous mainstream media reports, which their malicious research also incited. Primarily, this includes stories that began on September 23, 2016 by Yahoo News and its progeny. However, the defendants' pleadings remain completely mute to the fraud that their libelous research project played the essential role in egregiously instigating in the FISA court. As part of preliminary efforts to begin restoring the rule of law in the wake of this judicial disaster, the top leadership of many committees in the U.S. Congress, including the Senate Judiciary, House Intelligence, House Judiciary, and House Oversight Committees, have in 2018 disclosed significant evidence of precisely such atrocious offenses which the defendants sponsored and helped to manage in conjunction with their paid consultants. Despite having help from a large team of lawyers with drafting their memo, the defendants' initial pleadings in this case are dripping with the same types of misinformation and false pleadings that plagued the allegations from their dodgy dossier reports that they helped to introduce to the FISA court. So they're going through and basically saying, look, this has all been a scam to defame our client. And that's what's really happened to Carter Page. Have you noticed Carter Page has not been arrested for any crimes? There has been no indictment against him. Nothing. But yet he was the one that they got the FISA warrant to be able to spy on. And the reason they got the FISA warrant on him was so they could do what Dan Bongino calls a two-hop rule. They could do one hop to whoever Carter Page contacted, and then whoever those people contacted. So say, for instance, if Carter Page talked to Don Jr. and Don Jr. talked to his dad, then they could get Trump. That's how they did it. They wanted to have him as the jumping off point so they could make ripples out and be able to surveil a lot of people. But if you watch my video on the illegal queries, they were already doing that. And this was a cover their butt type thing. They had to come up with something and get the FISA court to be able to approve that warrant, because if not, then how were they going to explain already having all this information that they'd been spying on these people ahead of time? So this is why they had to get something on someone, and Carter Page was the fall guy. So this is why we need the FISA to come out, because when all of those things are unredacted, it's going to be clear that it was all a setup. It was something they were just trying to do. It was based on a bogus claim that this Yahoo article supported what they were saying. The problem was Christopher Steele told the guy at Yahoo this information. So it was like he wrote the dossier and then he told Yahoo about it, and then they used the article the guy from Yahoo wrote to support the fact that the dossier was accurate. I mean, it was circular. And this is what, if you watch my video on Nancy Pelosi and the wrap-up smear, that's what she was doing. I know the short little clip I have in that one video is where she's talking about the Republicans, but if you watch the next video that I did that was on Pelosi and projection, what she was doing is taking what the Democrats do and she was applying it to the Republicans. It's called projection, and that's what she was doing. She was accusing the Republicans of doing exactly what the Democrats do, and exactly what they did with Trump, exactly what they did with Kavanaugh, exactly what they've done many, many, many times. So if you get a chance, go watch that, especially the one about projection, because I show the full clip there and you can hear it all yourself, and you can see how she was manipulating it to make it sound like, oh, those mean old Republicans, when in fact she was doing it from the Democrat point of view. She was telling us what the Democrats do, something from their playbook, but she applied it to the Republicans because that's what projection is. They accuse other people of doing what they're guilty of. So anyway, I'm going to leave the rest of this because it goes on and it really is kind of entertaining to read, to be honest, because this guy doesn't pull any punches, the guy who made this up. And he really says it very clear that the Democrats did this on purpose and that there is now a lot of evidence out there that has come from all these congressional committees. So that's an important part of it. The congressional committees, as we've covered before in previous videos, cannot actually prosecute anyone. All they can do is say, hey, here's something wrong, and hand it to like the FBI or the DOJ. That's all they can do. It's the same as Horowitz. Horowitz, who is the Inspector General of the DOJ, he could go in and he could investigate things, but he had no teeth. And so that's why Sessions paired him up with Huber. Huber is a U.S. attorney. U.S. attorneys can impanel grand juries and they can prosecute. So contrary to what we're hearing out there and all these people saying, oh, Huber's just bogus, he's part of the deep state, he's not doing anything, he hasn't even interviewed these people, remember, he has been doing a lot. But it's an honest DOJ now, and they can't even acknowledge that there is an ongoing investigation on something. They're not supposed to do that. They're not supposed to say anything until the investigation is over and the indictments are put out. So in this case, the indictments are sealed. And to clarify one other thing, for those of you who think that the envelopes that were handed out at Papa Bush's funeral were indictments, no, they were not. That's not how indictments work. You do not give indictments to the people indicted. A sealed indictment is sealed until the arrest happens. So those people will not see the indictments until the arrests happen. And when the arrests happen, then they will see the indictments. And besides, if you look at the envelopes, they were not the right size for it. An indictment is an official legal document. It would not fit in those envelopes. Okay? So no, that's not what they were. Anybody who tells you they were indictments, no, that's just not it. They don't know anything about how the legal process works. The indictment will be unsealed, they'll be arrested, then they'll see the indictment. Okay? They don't see it ahead of time. That's just not how it works. So I don't know what was in the envelopes. I really honestly don't. I think because of the shape of them, it was not a standard letter of some kind. And I think because of how Jeb Bush scanned it so fast, it was likely a picture or a very, very brief text. Because even if it had been an indictment, he could not have scanned it that fast to understand what it was. And if you watched, it was very quickly. He absorbed whatever was on that page extremely quickly. So I wanted to say that here. Plus, there's also a video where it shows George W. writing something. And so it's very possible that that's what he showed to Laura. And then that's what she showed to Jeb. I don't know. Because when he showed that to them and they looked at him, his face just looked like he had given up, like it was over. I mean, that's really how he kind of looked. So I don't know. Nobody knows what was in him. All we know from Q is that it was a counter move. We don't know what that means. So it was something that they all recognized, something they all absorbed, and it was not something enjoyable. And yes, I know Mike Pence's wife got one too. So I don't know why. I really don't. My opinion after seeing them was that it was an invitation to the White House, and I think that was something that none of them wanted, because none of them wanted to see Donald Trump face to face. So that's just my personal opinion. But anyway, I wanted to present this to you. I wanted to show you a little bit what Carter Page is up to. And I want to remind you, too, that what happens when you have something in court is that all the evidence gets to come out in discovery. I wonder if this Carter Page lawsuit here is going to help bring some things out. So it could be very interesting what comes out in discovery. So I want to thank you all for all the subscriptions and everything. I know I didn't make my 40,000 by Christmas, but you all have been helping me out so much. So I really want to thank you for all the sharing my videos and everything. And I want to thank you too for all the comments, because I learn a lot from you guys. Keep working at it. Maybe I'll hit 40,000 pretty soon. I really hope so. It's getting up there. It's really happening fast. So Thank you again for stopping by, and I'll see y'all later.